Hello, and welcome to this training on holding education rights for foster youth. My name is Brittany Tannenbaum, and I am the Educational Advocacy Coordinator and Case Supervisor at San Francisco Court-Appointed Special Advocates. In this training, I will be giving an overview of what it means to hold education rights through the SF CASA office. I will also be covering information on who is eligible to hold education rights for a young person, the process for switching educational rights holders, as well as the legal rights and responsibilities of holding education rights for a young person in foster care through the SF CASA office. To start out this training, it's important to first answer the question of what exactly are education rights? Education rights are the ability for someone to make educational decisions for a young person. Generally, parents have the right to make educational decisions for their child unless their child is in a legal guardianship, their child has been freed for adoption, which means that the parental rights have been terminated, or the juvenile court has limited their educational rights. If a court decides to limit a parent or guardian's educational decision-making rights, it is also the responsibility of that court to appoint a responsible adult to be able to make educational decisions for the young person. In thinking about who may hold education rights for a foster youth, there are some people that are automatically granted the rights. These people include biological parents, adoptive parents, the legal guardians, or the youth once they reach the age of 18. Additionally, if the parental rights have been terminated and prospective adoptive parents have been identified by the court, these people are also automatically granted education rights. In certain situations, the court may decide to limit or terminate the rights of a parent to hold education rights. In this situation, there are a list of people who are eligible to hold education rights for a young person. These people include foster parents, relative caregivers, community members who have a special relationship with the youth, and you, a court-appointed special advocate. In order to best serve the needs of a young person, there are also certain people who may not hold education rights for a foster youth. These people are identified as anyone who may have a conflict of interest or receive money for the care of a foster youth, except for foster parents. These people include the youth's attorney, the school and district staff where the youth attends school, regional center staff if the youth is accessing services, the young person's social worker, if relevant, their probation officer, group home staff if the youth resides in a group home, the youth's therapist if they have one, and employees of the Department of Education. It is important to note that a youth may be assigned an education attorney by the court, and this person is allowed to hold education rights for a foster youth. These limitations exist to make sure that a young person is receiving all of the education support that they can and that there is no conflict of interest with the person that is holding their education rights. There are various reasons why an educational rights holder may change for a foster youth, and it is important for the court to consistently think about who is holding education rights for a young person. According to California Rule of Court 5.649, the court must identify the educational rights holder for the child on Form JV 535 at each hearing in a dependency or delinquency proceeding. During each of the hearings, the judge or commissioner is required to assess the current educational rights holder for the following. They want to make sure that they are available to be present for education matters for the youth, such as attending meetings and being available to speak with educators. They also consider their ability to attend to the education needs of the youth. So this means paying attention to the young person and what they may need in terms of their education. The judge or commissioner also reviews the willingness of the person to serve as the educational rights holder. Sometimes someone is not able to continue their role despite their best intentions. A couple of practical examples of when an educational rights holder change may need to take place is when the current person holding the education rights is unreachable, has passed away, or is possibly incarcerated at the moment. Another common reason that the educational rights holder may need to change is that the person is a former foster parent or CASA for the young person and is no longer able or willing to serve in this capacity for the young person. It is important in your role as a CASA or as an educational rights holder through the SF CASA office to make sure that the court is reviewing this information at each hearing and that the person who is identified as the educational rights holder is still available and willing to serve in this capacity within the best interest of the young person. When the designation for a youth educational rights holder is being changed to a court-appointed special advocate, the following process is typically followed. The first step is identifying that the current educational rights holder is unable or unwilling to continue holding education rights. The person currently holding these education rights could be someone such as a former foster parent or perhaps even the biological parents of the young person. Once it has been identified by the court that a new educational rights holder is needed, a search will happen to try and identify supportive adults in the youth's life who could hold these rights. Sometimes there may be a CASA already working with the young person who could take on this responsibility. In the context of this training, another situation that could occur is that an educational rights holder needs to be identified for the young person, but there are currently no adults available in their life who can take on this role. In this case, a referral may come to the SF CASA office, and SF CASA will appoint an educational rights holder to serve this youth. Once a court-appointed special advocate is identified to serve as an educational rights holder for a young person, the youth's attorney will file a JV 535 form with the court to assign the CASA as the educational rights holder. On the slide, I have included a picture of part of a JV 535 form. It is important to make sure that the information included on the JV 535 form for your educational rights holder designation is accurate. Under the name section should be your legal name. Under the address section, you should list the San Francisco Court-Appointed Special Advocate office. Under telephone and email, you should list your own personal contact information that you use for CASA communications. It is important to make sure that these lines are both secure and confidential, as it's important to protect the information of the young person. Under relationship to child or youth, you should be identified as an SF CASA educational representative. Although it will be the youth's attorney filling out and filing this form, it is important for you to collaborate with the attorney while they are filling out this form to make sure that the information that is filled out about you is accurate. Once the JV 535 form is filed with the court, you will gain the legal rights and responsibilities of holding education rights for the young person. There are many legal responsibilities of holding education rights for a young person. One of the most important is monitoring the educational progress and needs of the young person. Most often, this happens by receiving report cards and progress reports, but by also reaching out and communicating with the school or regional center staff, as well as other providers about the young person's education. It's also very important to talk to the young person themselves about their educational progress and check in with them about what their needs may be around school. It's also important to attend all of the education meetings for the young person. In the rare circumstance that you're unable to attend an education meeting as the educational rights holder, it's first important to make sure that you are attempting to reschedule the meeting at a time that you could make it. If you're unable to reschedule the meeting, it's best to call in, or if that is not possible, figure out another plan with the providers that are involved to make sure that the educational needs of the youth are being met. In your role as an educational rights holder, you are legally required to always make sure you are advocating for the best interests of the child in education decisions. In your role as an educational rights holder, you are required to provide information to the court about the youth's education through the JV 537 form during each of the youth's hearings. On this form, you're able to talk about the youth's education, including services they may be receiving and the progress that they're making in their education. Additionally, this form allows you to identify certain education needs for the youth that may not be met at this time and recommendations for how to support this youth in their education. It is also your legal responsibility to inform the court if your ability to serve as an educational rights holder for the young person changes at any point. It is extremely important for you to be honest about your ability to serve as an educational rights holder and to inform the SF CASA office if your ability to serve in this capacity changes at any point, because it is important for the youth's educational success. Once you have been granted educational rights through the court for a young person, there are many things that you are legally required to be notified about, and you are able to start making decisions for the young person around their education. There will be further trainings in this series to explain each of these situations, but I wanted to give you all a good overview of the different things that you are required to be notified about and to make decisions about. To start out, one of the most important things is the school placement for the young person. As an educational rights holder, you are the person who is able to enroll the youth in school. This also means that you are the person who gets to help them determine where the best place is for them to be attending school. Once a youth is placed in a school, you are also the person that the school should be contacting regarding the progress and meetings for the young person. There are various meetings that a young person may have going on in their education based on their individual educational needs, but it's important to note that the school is required to notify you about all of these meetings and encourage your attendance at these meetings. You will have legal access to the youth's grades and attendance so that you can best monitor the progress with the young person, and teachers are required to communicate with you as the educational rights holder about the youth's education. If the young person that you are working with is in special education services, you are also the person who gets to sign off for services and be part of the team meetings, including IEP meetings, for determining the best services for the young person in special education. In a circumstance where a youth is not receiving special education services, but you feel that maybe they could benefit from these services, you are also the person who is able to request an assessment for special education services for the young person. In talking about special education services, it's also important to think about early intervention services. These services are for young people from birth to age 3 years old who may have a disability that is affecting their learning. As the educational rights holder, if you are working with a young person receiving early intervention services, you will also be a part of the team making decisions regarding these services. You are also the person who is able to sign off on the individualized family service plan for this young person to receive services. If you are working with a 0 to 3-year-old as their educational rights holder, you are also the person who is able to make a request for an assessment for services if you feel that the young person could benefit from early intervention services. If a situation arises for the young person at school where they are involved in disciplinary action, you are also the person who is required to receive notification about the different things happening in regards to this situation. To give an example, if a young person is being suspended from school, the school is required to call and notify you that this is taking place. The school is also required to let you know about the upcoming meetings regarding the incident and to have you participate in these meetings regarding the disciplinary process for the young person. When it comes to high school, there are certain laws in California to help foster youth be able to graduate from high school despite the transitions that they may face in placements during their time in foster care. As the educational rights holder, you are able to work with the youth and their team, including school staff, to determine if it would be within the youth's best interest to utilize the rights covered by AB 167 and 217 for high school graduation. As the educational rights holder, you would be the person to sign off on utilizing this plan. As you can see by this list, there are many things that the education rights holder is entitled to make decisions about and to be notified about. As I said at the beginning of this slide, there will be many more trainings in this series to be able to support you with making decisions regarding this various things for a youth's education. Beyond the legal rights and responsibilities of holding education rights through the court, we also have requirements of holding education rights through the SF CASA office. We have these requirements so that we are best able to support you and the young person in making education decisions for the young person. One of the requirements of holding education rights through the SF CASA office is regular communication. We expect that you regularly connect with the young person around the education because it's important that their voice is being heard and that you are able to understand things from their perspective to best advocate for them in their education. We also ask that you maintain consistent contact with the SF CASA office, including notifying us of any changes in the youth's education, such as a school placement or a new IEP for the young person. We have you submit monthly contact logs to the SF CASA office so that we are aware of the different things that you are doing with the young person and your time with them and working around their education. As mentioned earlier, you are able to update the court about the youth's education at each hearing through the JV 537 form. This form is required to be submitted to your case supervisor 3 weeks prior to each hearing so that we are able to support you with making sure all of the relevant information is included and to get the form submitted to the court 2 weeks prior to the hearing date. As developmentally appropriate, it's also very important to include the youth in decision making around their education. This helps them to prepare for their future and to understand what is happening around their education. Additionally, if the case is in reunification and it is appropriate, as you have discussed with your case supervisor, you will want to include biological parents and education matters for the young person because it is important for them to understand what is happening for their young person in school and for them to be as involved as possible in helping this young person's education. In holding education rights through the SF CASA office, we want to make sure that you feel prepared to be able to make decisions for the young person regarding their education, and that you feel supported to be able to do so. In holding education rights through the SF CASA office, we ask that you please familiarize yourself with the laws that are relevant for the young person's academic rights. We also ask that you please participate in trainings around education topics that are offered through the SF CASA office as appropriate. And, most importantly, we ask that you please advocate for the youth's best interests in all of the educational realms, including their school placement, course placements, special education services, discipline and attendance concerns, extracurricular activities, and other academic resources. Thank you for taking time out of your day for this training on holding education rights for foster youth through the SF CASA office. If you are interested in holding education rights through the SF CASA office and are not already working towards this, please contact the SF CASA office at 415-398-8001 and ask to speak with the Educational Advocacy Coordinator. For those of you already working towards holding education rights for foster youth through the SF CASA office, I invite you to please continue with the next trainings in this series on holding education rights.